is that the primary responsibility of judging that situation is not to ask whether Freshfields Council knew or didn't know or had other interests that were not communicated to Guatemala. The first and foremost obligation to disclose is, as was explained by Mr. Smith this morning, and the person who was involved in more than 20 cases did not declare the TCC and was involved in more than 15 cases, did not declare that, and that was Mr. Alexandrov. We need to begin with the person with that responsibility, and that was Mr. Alexandrov. Mr. Torterola, one thing is the duty that Mr. Alexandrov may have or may not have had to disclose certain things, and another thing is whether Guatemala could have obtained that information through other means, but you have said that Guatemala was unaware. Well, I can say that I personally was unaware. I had that conversation with Guatemala, and I informed myself.
Yes, and I just want to object because this is testimony, and I held off doing it before, but if he's talking about what Guatemala knows and saying...
If you want to be on record, 1 second, please. This is not being interpreted into Spanish.
Should I?
It is being interpreted into Spanish.
Yes.
Thank you. So I was just raising an objection because Mr. Tortorella before made a statement, an evidentiary statement, saying that Freshfields did not tell Guatemala something. There was no witness testimony on the record. Of course, if there was, we would have an opportunity to cross-examine, perhaps even ask for document production. And now he is talking about his personal knowledge, saying, I think this is catching up, but I was personally unaware. I had that discussion with Guatemala. I informed myself. I mean, we should not be having factual testimony at this point in this proceeding. It's improper.
Okay, I just wanted to put some context into something that you mentioned in passing, but I wasn't sure because...
Yes, I mean, you asked me. That's why I responded.
I did ask.
I think the difference is also a matter of constructive knowledge as opposed to specific individuals.
They will have a time to argue that. They will have a time to argue that.
No, I meant the
you
question.
put me a question. The Madam President put me a question and I responded. That's it. I mean, everything about all the other issues. And this is not different. I'm sorry. This is not different from what we said in our pleadings.
It's in your pleadings. I just wanted to make sure.
Yeah, it is in our pleadings. I mean, with the exception of what responded to you, everything else, it is in the pleadings.
Just saying, your question, Madam President, was Mr. Alexandrov may have had or not to disclose things. Another thing is whether Guatemala could have obtained that information through other means. That is a constructive knowledge question, whether they could have, not whether they did, whether a specific individual knew or relayed information. And as far as what is in their pleadings, there is one sentence in their pleadings, which again is improper, which is a factual statement. It is only one statement, which says Guatemala did not know, but that also that's without any evidentiary support.
Yes, I think that there is a problem here with the interpretation. The interpretation, I mean, your question was not what it has been read in English. Your question was different. And I will read it from Spanish for the translation again. Your President, Madam President, and you can put the question yourself again, I mean, if you wish. Dice, Doctor Torterola, una cosa es la obligación que
One thing is the obligation that Mr. Alexandrov could have had of making some disclosures. And another one is a marginal argument presented by TECO, whether Guatemala independently could have obtained that knowledge by other means. And you declare that Guatemala did not know about that. And I answered that Guatemala did not have knowledge of that.
Would have obtained that knowledge.
Yes, I mean, it was a clear question and I responded. I didn't anything wrong in order to be interrupted in my
I'm
presentation.
just saying the interpretation again said could have.
Yeah,
No,
but it's a wrong
so-
interpretation.
Well,
It's
that
a
is
wrong
not-
interpretation.
Would have.
Yes.
Whether Guatemala would have obtained it through other means. And Dr. Tortora confirmed what was in the written statements that Guatemala did not. He's not testifying to it. It's just confirming what was already in the record, that Guatemala did not obtain that. According to them, Guatemala did not obtain that. According to Guatemala, they did not obtain that knowledge, either through Freshfields or otherwise.
And may I, on that, I have two issues. There is no evidentiary support in the record. There is one stray line in the pleadings that says Guatemala did not know. That is not evidence. There is no witness statement from anybody saying whether they knew or obtained any information. And secondly, the other statements that Mr. Tortorola made in response to your question was with respect to his personal knowledge. So that did go beyond the question, and that is testimony.
Okay, maybe we can strike what I said, that it was my personal knowledge. The other thing, it's in the record, we can locate it for you.
It's an
And
allegation.
if it's not in the record, we can strike it. You put a question to me and I responded the question.
I think it's in the record that Guatemala only learned later after the resubmission proceedings. I think that's an allegation that's in the record.
It's an assertion in the pleadings, as I
Yes.
understand it. It's not evidentially
It's
established.
not evidence. It's an allegation. It's an argument.
Okay. Could I request to the secretary to tell me how
You have used 2 hours, 26 minutes and 41 seconds out
Okay.
of the 2 hours.
Okay, I have 3 minutes then. Thank you. Tal vez lo único que quisiera decir es que
That's the only thing I wanted to say. Well, I want to say three things. Paragraph 250. We put it on the screen. The committee says that the influence of Mr. Alexandrov amongst the arbitrators would have been perceived differently in every material aspect had they known the full facts and extent of his and Cecilia Austin's long-standing relationship with the Brattle Group and La Puerta. And that is indeed of application here. The tribunal says what the committee can also conclude is that due to this non-disclosure, Spain lost the possibility of a different award. Guatemala lost the possibility of a different award. The committee also found that the non-disclosure violated Article 52(1)b, and that is difficult to conceive a more fundamental rule of procedure than the one that indicates that the tribunal resolving a case be independent and impartial. I repeat, a request for annulment of the award, whether partially or fully, as relevant. Thank you very much, members of the committee.
Yeah, question?
Could I just foreshadow a question? We are going to, as an annulment committee, consider some questions to put to council for Friday, but there's one issue that I'd just like to raise, which arises from paragraph 227 of the ISA annulment committee decision on slide 144 of claimants Guatemala's presentation, and it relates to the role of experts in arbitration. Some of you may be aware that I have some well-developed views which have been expressed in writing about the role of experts in arbitration. The most detailed version of which is in a paper presented to the ICC Institute in Paris last year, and which is on my website. In that material, I discuss the history of and the duties of tribunal and party-appointed experts, and establish, I think, that tribunal-appointed experts are not advocates engaged by counsel as an extension of their advocacy, but rather are there in the proceedings to assist the tribunal, and although appointed and paid by parties, owe a clear duty of independence and assistance to the tribunal. Now, this is something which is not discussed in the ISA decision, and I'm interested in understanding whether what view each party has about the role of experts in arbitration, including ISDS arbitration, and whether that role is relevant at all to the question of the issue of disclosure. I'm not expressing a view on that, but I don't think this issue has been ventilated in the ISA decision or indeed in council submissions so far. It's for reply, perhaps, not for answer now.
Okay. Thank you very much. The only thing that I would like is just to mention that I think that I've been quite clear on that. And I mentioned paragraph 227. And I also said that the tribunal, the committee in ISA had the courage to spell out the kind of relationships that are going on in our ISDS practice between experts, especially experts in damages, and counsel. But as you suggested, I will like to read your article that I confess that I have not read, and I will answer to your question tomorrow. Thank you.
Ms. Meneke, do you perhaps need a couple of minutes, or are we ready to continue? Oh, sorry.
I'm ready in a half a second.
Okay, excellent.
So, Madam President, members of the committee, good afternoon again. So this case has the unfortunate distinction of being one of the longest running disputes at ICSID. TECO filed its claim nearly a dozen years ago for a breach that occurred 2 years earlier. And as you're well aware, the original tribunal, committed annullable errors. But given the limited competence of an annulment committee, which is unable to modify or correct an award, TECO was then compelled to resubmit its claim to arbitration in order to recover the amounts that had been wrongfully denied to it. Now, in the meantime, and you can see this long history on our first slide here. In the meantime, while this resubmission proceeding was ongoing, TECO also sought to collect on the unannulled award for the historical losses that had been awarded to it, the historical damages and the interest that had been awarded to it, that Guatemala had tried but failed to have annulled. And you can also see here on this first slide that that effort lasted 4 years. It took longer than the resubmission proceeding for TECO to collect on an ICSID award that was final, that was not subject to any further recourse, and that under the ICSID convention had the status of a final judgment of a court in an ICSID signatory state. Now, I'd ask the committee to keep in mind that Guatemala opened its reply submission at paragraph 4 by stating, and I quote, "TECO has attempted to confuse the committee," end quote. And yet, if you had only read Guatemala's memorial, you would be forgiven for thinking that TECO had prevailed on its entire damages claim, because you will search in vain throughout that entire memorial for any mention of the fact that the vast majority of TECO's damages claim in the resubmission proceeding was rejected. There's simply no mention of that fact whatsoever. Instead, in its memorial, this is what Guatemala said, and I quote again, "By and large, the tribunal adopted Mr. Kaczmarek's valuation of TECO's damages. The resubmission tribunal might not have readily and wholly endorsed Mr. Kaczmarek's valuation as it did in the resubmission award, had it known of Dr. Alexandrov's relationship. But as you can see here, and we've mapped out what the claims were throughout the proceedings, and as you also know well by now, it's patently false. Because in the resubmission proceeding, TECO did obtain additional damages and interest, but it only received a very small portion of the relief that it sought. It went in asking for $195.7 million, and it came out with $26.8 million. That is not a wholesale endorsement of Mr. Kaczmarek's valuation by any stretch of the imagination. Now, in our view, the majority of the resubmission tribunal was wrong to deny TECO damages for the loss of cash flow or the loss of value for the period after 2013. That was damages that TECO, in our view, would have earned, but for Guatemala's breach. But as strongly as we believe that, we also recognize that this proceeding has come to an end. So while we may disagree very, very strongly with the majority of the resubmission tribunal's reasoning, the fact is that the award is reasoned and that both parties were accorded due process, and that is all the parties have a right to. That's all they can ask for. Now, once the award and the original annulment decision were issued, it was all but a foregone conclusion that TECO, at a minimum, would be awarded damages for loss of value damages for the period up through 2013. And this is because those damages were a logical consequence of the original award together with the original annulment decision. And this is one of the reasons why we've spent quite a bit of time discussing the procedural background of these proceedings, because it's important to us for you to understand that at the time when we submitted our claim to the resubmission tribunal, it was all but given that we were entitled to the loss of value damages up through the end of the 2008 to 2013 tariff period. And the focus of the resubmission proceeding was not on those damages. It was instead on the loss of value damages from 2013 onward through the end of the concession period, which was another 35 plus years. I believe 33 or 35 years. And in essence, and this may respond somewhat, hopefully, to the president's question earlier, but without getting into enormous amount of detail. In essence, what TECO had argued was that because the 2008 to 2013 tariff was unlawfully set at a low rate, the value of the company was diminished. And it was diminished not only for the period of that tariff, because the original tribunal had determined the tariff should have been at X, say $200. Instead, it was set at Y, $100. So we lost the interim, the differential during that period of time. But we said that the diminishment in the value was greater than that, because when Guatemala had decreased the tariff, they changed the methodology. And we said that when you were forecasting the future cash flows for that company, anybody would forecast the future cash flows for the next tariff period at an equally low rate. But for the breach, we would have been entitled to it at a higher rate. And that's why our damage is so extended beyond that tariff period. And so we argued that that's what anybody would do, whether we stayed in Guatemala and continued to operate the company, or whether we sold, that someone would pay less for it because they would consider that at that point in time, the tariffs would stay at this artificially low rate. Guatemala, on the other hand, argued, no, if you award them losses, the lost cash flow for those future periods, you're in anticipating that Guatemala will continue to breach the treaty in the future. That was the crux of the debate between the parties. What was uncontested and remains undisputed is that the tariffs are set for 5-year periods, and the distributor's revenue is set. That's the only revenue they make is on this VAD, which is a portion of that tariff. So TECO, when they sold in the middle of that period, if they had stayed in Guatemala, the original tribunal already had said the tariff should have been X, instead it was lower, and you get the differential. We sold in the middle of that tariff period, and the resubmission tribunal said it's only logical that we also lost that differential for the remainder of the tariff period, because anybody purchasing the company, the only revenue they're going to get is from that tariff. They're obviously going to pay at the lower tariff rate than if the tariff was higher. And you can see that on this next slide, slide number 4. That is what the resubmission tribunal decided. In paragraph 86, they say it is axiomatic, it's only logical, that the 2008 to 2013 tariffs must have been a factor in any rational valuation of EGSA, and that the tariffs would have tended to depress the value of EGSA below the level at which it would have been had the tariffs had they been higher and had they been expected to continue at that rate. And then they say it's evident that the shortfall in the cash flow that caused the original tribunal to award historical damages for the period from August 2008 until October 2010, when EGSA was sold, would continue until the end of the third tariff period until 2013. Because again, although we submitted our claim to arbitration in 2010, so anything after that were forecasted cash flows. But for the tariff, you didn't have to forecast it. It wasn't changing. And then for what the tariff should have been, the original tribunal already decided that. So that would not have changed. So it was really only for the post-2013 period that you are then forecasting a tariff that you don't know what it will be. And that's what the president of the resubmission tribunal asked Guatemala. He said at the resubmission hearing, I think claimants taken the point of view that the historical damages claim logically could go forward to 2013. We're calling it loss of value because it was after the date we submitted the claim, but it's part of that same tariff period. And what does Guatemala say in response? I think in terms of going to 2013, in terms of that question, that must be right. And that really shows you that the entire debate during the resubmission proceeding was about the post-2013 damages. With respect to the damages from 2010 to 2013, Guatemala conceded that given the original award, given the fact that they had failed to annul that portion of the original award, of course, we would have had damages for the remainder of that tariff period. And I just note that this exchange is cited by the tribunal in the resubmission award at footnote 122. Now, the resubmission tribunal's award of damages thus was, in TECO's view, the most conservative award that it could have issued based on the original tribunal's finding of breach and the annulment decision. Now, after failing to acknowledge in its memorial, anywhere in its memorial, that TECO had not been awarded the vast majority of the damages that it had sought, and erroneously stating that the resubmission tribunal had, quote unquote, wholly endorsed Mr. Kaczmarek's valuation, after we point out in the counter memorial that, of course, that's not the case. In the reply, Guatemala changed course and came back and said that, quote, and this is from paragraph 365, that TECO suffered a staggering loss in these proceedings. For TECO to say that Guatemala failed in these proceedings is thus not only a gross mischaracterization, it is delusional, end quote. Now, think if TECO failed so miserably in its claim, how can Guatemala allege at the same time that Dr. Alexandrov was biased, that he tainted the rest of the arbitral tribunal against Guatemala, and that there would have been a materially different outcome had the alleged disclosures been made? By its own admission, Guatemala cannot show this. And in our view, this reveals the obvious, opportunistic, and the bad faith nature of Guatemala's application. And that pretextual nature of Guatemala's arguments and the challenges that it has made is laid bare by its actions over many years to avoid payment of the unannulled portion of the award. And you can see here on this slide, before the former annulment committee, now this is 7 years ago when we were last before an annulment committee. This is the committee's own quotation language, saying Guatemala has represented to the committee that it undertakes to comply with the award if it is not annulled. And we heard something similar this morning. It was after that, after the award of historical damages and interest was not annulled, we therefore wrote to Guatemala asking them to pay us, giving them our bank details. And what happened instead? Guatemala filed, we needed to file in U.S. District Court to enforce the award because Guatemala refused to pay. And when we moved for enforcement, Guatemala raised not only every argument imaginable, but arguments that directly contradicted what they had argued before the tribunals, and which has, in many cases, similarities to what they're doing before this annulment committee. So, for example, they first argued that the award cannot be enforced because the entire award was annulled. There's nothing left to enforce, it's a nullity. Now, at the same time, we were before the resubmission tribunal. Of course, they were not making that argument before the resubmission tribunal, but before the court, they did. And that was back in November of 2017. And a year later, September 2018, the court dismisses that argument and says Guatemala's contention that the relevant award is a nullity is unconvincing. But then they go on to make further arguments, and they argue that the Iberdrola claim, was dismissed, and that our tribunal was obligated as a matter of res judicata to dismiss TECO's claim and to follow Iberdrola. Now, not only had they not argued that before the original tribunal, they had acknowledged that the Iberdrola award had